43, may I request your Lordship to have order 39, because that will define the ambit of 39 1 and 2.
Sir, you are undisputedly, your application is for demolition.
That is correct, my
It
lord.
is a mandatory injunction.
Certainly, my lord. There is no
Interim mandatory injunction.
interim mandatory injunction is not covered. That is what I am drawing my lord's attention to. It is only under 151, my lord, that interim mandatory injunction can be.
No, sir. No, sir.
My lord. My lord wanted me to read order 43, rule 1, sub-rule R.
C.
My lord.
An appeal lies from the following orders under the provisions of section 104, namely,
My lord.
come to R.
My lord.
An order under rule 1 and 2, rule 2A, rule 4 and rule 10 of order 39.
My lord.
Now go to order 39.
My lord.
You mean to say there is no power to the trial court to pass an interim mandatory injunction?
My lord, under order 39, and therefore 151.
Mistaken.
My lord, I'm so sorry.
It has got every power.
My reading says that, my lord, with respect. If my lord will permit me, my lord, may I read one?
Yes.
Cases in which temporary injunction may be granted, wherein any suit it is proved by affidavit or otherwise that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit, or wrongfully sold in execution of a decree, or that the defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditors, that the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit, the court may by order grant a temporary injunction to restrain such act or make such other order for the purpose of restraining and preventing the wasting, damaging, alienation, sale, removal or disposition of the property or disposition of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit, as the court thinks fit until the disposal of the suit or until further orders. And then, my lord, 2, injunction to restrain repetition or continuance of breach. In any suit for restraining the defendant from committing a breach of court, contract, or other injury of any kind, whether compensation is claimed in the suit or not, the plaintiff may at any time after the commencement of the suit and either before or after judgment apply to the court for a temporary injunction to restrain the defendant from committing the breach of contract or injury complained of, or any breach of contract or injury of a like kind arising out of the same contract or relating to the same property or right. The court may by order grant...
There is the prohibition for mandatory. Suppose,
my lord,
a person on the middle of the road constructs a wall and says, tomorrow I will not permit anyone to use this road. Does not the court have the power to construct the wall by issuance of an interim mandatory injunction?
My lord, the court does have a power, my lord. But with respect, under section 151, my lord.
Look at your prayer. What is that you are asking?
My lord.
Under the guise of 151, you are asking for the prayer of mandatory injunction.
With respect, there is no... May I just make this submission? My lord, lordships in one judgment, my lord, if I may just...
You will be taking the risk.
My lord.
So instead of that, if you want to pursue your order 39 rule 2A, you would be in the safe zone. Without being influenced by observations made here, let that application be considered.
My lord, if that is...
Demonstrate.
My lord, may I just... My lord, I understand, my lord, what is falling from your lordships. That's why, my lord, in the first place, only when my lord said that I
No question of clubbing this application.
My lord, otherwise, my lord, this order which has...
Assuming for a moment's sake, you succeed in order 39 rule 2A.
Clubbing is not...
Then my lord may remand back before the High Court, my lord, setting aside this order under Article 227.
Assuming for a moment's sake that you succeed in order 39 rule 2A.
My lord.
What happens?
39 rule 2 again.
Once
my lord.
Succeed in 39 2A. Section 144 comes into play.
My lord, it's restoration. That is right. Restoration, my lord.
What is there available to the court?
My lord, restoration.
So ultimately, whatever you want to ask here, well, you go and ask them. What is the recourse?
My lord, the difficulty is this. If I will just place for a lot.
Subsequently, the court commissioner also has been appointed.
So he has given a report that the order has been violated.
What is the difficulty, please?
My lord, the difficulty is this. In 151 application, my lord, I had sought a specific prayer before the Honorable Court that a direction be given to the police to ensure that it is not further violated and the structure be demolished. These were two prayers that I had sought, my lord. In order 39 rule 2A, my lord, the prayer that I have sought is that there is a breach of the injunction order by raising of my lord's fencing. That's a separate thing altogether, not the boundary wall. So if my lord will kindly permit me, I'll modify my order 39 rule 2A, and my lords may fix the outer limit. Otherwise, my lord, the whole purpose of approaching the honorable court stands frustrated because otherwise the matter will never be decided. So if my lord will give an outer time limit that within 6 months it has to be disposed of, my lord, that will take care of my interest, my lord.
With amendment.
For fixing a time limit of 39(2)(a), no problem.
My lord, I'm good.
So far as amendment is concerned, this is not an issue before us today, so we should not embark upon.
My lord.
2. Third, so far as this order is concerned of 151 application,
My lord.
in which limited order has been passed, whatever it is,
My lord.
that order may sustain, unlike, because of the order of the High Court, we are not interfering to that. Third, fifth, suppose 39(2)(a), if it is found there is a breach, then the power of restoration is there, then at that time you can apply. But you don't ask here, that's 151 may be added with this,
We did prayer.
restore that order, trial court order may be set aside and let it be sent for that. We can't say so. For amendment, you go there. We are not denying. That stage has come, we can't say. We can't say today.
Well, the only difficulty would be this, my lord, I
We don't
understand.
have any difficulty.
But they would say, my lord will fix the outer limit, it will be decided. But when I'll move an application for restoration, that will remain pending for years to, my lord, multiple years to come.
Ask everything.
So, my lord,
Don't presuppose anything and don't ask anything for presupposition of
We
it.
did prayer.
if I may just show page 43, my lord. And listen, page 43, my lord.
Yes, let us understand what you want.
My lord, today there is a misappeal pending where learned friend is also appealing arising out of maintainability of the suit.
No, which appeal is pending?
Misappeal number 17 of 2020
What?
challenging my application for that suit is not maintainable, that was dismissed. Against that,
It has got nothing
No.
to do with this.
as this appeal is pending, they are also appearing in the appeal. So nothing is happening in the suit. As of now, unless that